imagine you're just chilling at home, scrolling on your phone, and a casual WhatsApp message pops up.
Happens all the time.
Right. But it's not a meme from a friend. It's from the local police, ordering you in for questioning. Your heart drops. I mean, could missing a text actually lead to jail time?
It's a terrifying thought.
It really is. Welcome to today's deep dive into a massive 2025 Supreme Court of India judgment, Satender Kumar Antil v. CBI. We're looking at a high-stakes collision between modern digital convenience and your fundamental human rights.
Right, so the background here is that India recently overhauled its criminal code, bringing in the BNSS. And the state of Haryana went to the Supreme Court arguing, hey, this new law was modernized to embrace technology.
So they wanted e-summons through apps like WhatsApp to be the new normal.
Exactly. They argued it should become standard operating procedure for the police.
Which sounds incredibly convenient for the police.
Fairly convenient.
But I imagine there's a huge catch. What happens if you actually miss the message? Or it goes to spam?
That is precisely what the Supreme Court was concerned about. And we really need to slow down here to unpack this, because they looked closely at Section 35 of the BNSS. This is the rule governing police notices asking someone to appear for an investigation.
Okay, and under the law, if you ignore a Section 35 police notice, the police are authorized to arrest you.
They are. And because the consequence is a direct threat to your freedom, the court brought in Article 21 of the Constitution that's a fundamental right to life and personal liberty.
So because the stakes are literally your physical freedom, the court decided that relying on a digital notification is just too risky.
Precisely. The court ruled that physical delivery is a mandatory constitutional safeguard. It's not just some outdated procedural technicality you can wave away for convenience.
Wow.
You simply cannot risk someone's freedom on a WhatsApp blue tick, the potential for a fabricated message.
Or a hacked account.
Yeah, or simply a missed notification. It's too high when jail time is on the line.
I was looking at the state of Haryana's argument, though, and they brought up Section 530 of the BNSS, and that explicitly allows electronic modes for trials and inquiries. So if the new law permits digital summons for trials, why didn't the court allow it for police investigations?
That is where the Supreme Court applied a really brilliant interpretation. It's the principle of intentional omission. Lawmakers explicitly wrote that tech could be used for trials and inquiries, but they deliberately left the word investigations out.
Oh, so it wasn't a typo.
Not at all. If Parliament actually wanted the police to use WhatsApp for questioning suspects during active investigations, they would have explicitly written it into the statute.
But wait, if courts can use digital systems for their summons, why can't the police just, create a secure digital seal for their WhatsApp messages? Wouldn't that solve it?
It comes down to the critical difference between a judicial act and an executive act.
Okay, break that down for me.
A court summons is a formal judicial act. It comes with built-in oversight and a verifiable digital image of the court's seal. But a police notice is an executive act. The police operate out in the field, making rapid, unilateral decisions.
Oh, I see. So if you remove the requirement for physical paperwork,
You remove a crucial layer of friction that prevents the arbitrary abuse of police power. Physical service ensures there's an undeniable paper trail before someone's liberty is threatened.
that makes perfect sense. So let's talk about what this means for you in the real world. If you get a WhatsApp DM from a local inspector asking you to come in, it is not legally valid service.
Right.
But I assume the advice isn't just to block the number and go about your day.
Definitely do not just block them. You should use that heads up to your advantage. Consult a lawyer immediately and demand that the police provide proper physical paperwork before you cooperate.
Make sure your rights are strictly documented from step one.
Exactly. And for the legal professionals listening, this precedent is a powerful defensive tool. You can actively use it to quash arbitrary arrests where police try to justify a detention by claiming someone evaded a digital message.
It's a vital reminder that no matter how rapidly society and tech evolve, the constitutional safeguards protecting our personal freedom must remain untouchable. Convenience just can't come at the cost of liberty.
The law has drawn a very firm physical boundary here,
Yeah.
basically protecting your inbox from executive overreach.
Which leaves you with something to ponder long after this deep dive ends. If the police are strictly barred from casually sliding into your DMs to summon you, how else might they start using your massive digital footprint to investigate you before they ever even knock on your physical door?